This is week 3 continued after an interruption by the 4-year-old child. So sorry about that. Subsection B is talking about prevention by deterrence. There's a reading in an article by Bagaric and another person whose name has slipped my mind in the readings this week, which talks about some research into deterrence and whether or not it has been successful. There are some statistics in both the lecture slides and in those readings about the success of deterrence. So that's something that you can be thinking about and looking about whether that actually achieves its purpose. General deterrence can be more useful in some sorts of crimes than others. Things where people actually have to exercise a level of logic and risk-benefit analysis, weighing up the benefits of their decision, are something that's much more likely to be where general deterrence is likely to be useful. So things like white-collar crime, general deterrence is something that is significant. Crimes where offenders are acting as this on the spur of the moment or to get their next drug fix, so a break and enter or drug possession, things like that, in my view, general deterrence is much less likely to be significant because general deterrence requires somebody to enter into a thought process of, if I do this, what's going to happen to me? And my opinion on that is would be that high level of thinking is not really present when somebody's about to commit an offence of that variety. The theory of deterrence is that the greater deterrence, the greater the sentence there is, the greater the deterrence it is. And you can have a look at the statistics in terms of short and long jail sentences as to whether that is in fact true. The other type of deterrence is specific deterrence. So when a person continues to disobey the law, then the specific deterrence is in relation to trying to stop them from disobeying the law. An example of that might be for a driver who continually drives while disqualified. Eventually, the court will sentence them to jail and keep increasing the severity of their sentences to try and curb their behaviour. There are some circumstances where it's inappropriate for general deterrence to be applied specifically for that offender, and this was confirmed in the case of Muldrock and the Queen, 2011 244 CLR 120. Some examples where it's inappropriate to use general deterrence are things like in relation to children or offenders who are suffering from a mental condition. It's important to note that regardless of some of the problems that the concept of deterrence brings and whether it is actually successful or not, it still must be applied by the court, and the court may be in error if it doesn't consider deterrence. And that's confirmed in R and Miria, 2009, New South Wales CCA 68. Now, just note again that all of the cases that I'm referring to are in the bench book readings for this week, so if you're missing those references, just make sure you do your readings there and you will find them. Subsection C is in relation to protection of the community. This is an interesting part of sentencing because there's a consideration of preventative detention, so weighing up what might happen in the future as opposed to protecting the community because of the offence that just occurred. A court is not required to make a finding beyond reasonable doubt that the offender will reoffend, but there must be a risk established in order for that to be a significant factor. Subsection D is about rehabilitation of the offender. And part of this aim is to address the underlying issues causing the offender to commit offences. It's a wider purpose than to not reoffend. It's to help the person become somebody who contributes to society in a productive way. Rehabilitation is particularly important when it comes to young offenders. When you're talking about rehabilitation in custody, it can look like things like sex offender programs, anger management counselling, drug and alcohol rehabilitation, and violent offender programs. Some of the problems that arise in terms of access to rehabilitation in custody is under-resourcing. Not all programs are available to all inmates and in all jails, so there are significant problems with how those programs work in practice. Subsection E, to make the offender accountable. That's essentially saying to the person, you did something wrong and there is a penalty attached to it. Subsection F, to denounce the offender. So that has a couple of parts to it. The first is a message to society that the offender did the wrong thing. And the second is the message to the offender that the community does not accept their behaviour. Subsection G, recognising harm done to victim and the community. This takes into account the harm done by the offender in determining determining their sentence. The next question to look at is, does sentencing work to deter? Now, I talked a little bit about this before, and in the slides I've extracted some statistics from the article regarding specific deterrence. Just to note a few important features there from a 2010 study into reoffending. So more than half of the people surveyed and they were in jail had previously served a term of imprisonment. And there's some interesting statistics on that slide about how deterrence works, about different periods of offending and jail sentences and how that impacts upon whether somebody is likely to be re-imprisoned. It's always great to have a look at statistics to see what story they tell, because often that story is different to the story that you might have established in the media. There are also a few activities to have a look at in relation in this week's module in relation to the case of Kieran Loveridge and the death of Thomas Kelly. So I commend those to you. The activities are in the slides and in the modules, and if you'd put your answers on the discussion forum, I'd love to give you some feedback on them. I look forward to seeing all of your assignments. Bye for now.